No, Lord Advocate.
Thank you, my Lord. My Lords, I would like to make 4 preliminary points arising from the submissions that the Court has already heard, and then to make some submissions on the question of justification, which I hope will assist the Court in the approach which it may take to this particular matter. First of all, on the question of charging practice, can I first of all say that as a matter of law, a charge is not a prerequisite for referral either to the Procurator Fiscal or to the reporter. There is no formal guidance to police officers in relation to charging decisions, but it's my understanding that police officers are trained that, as a general rule, where there is sufficient evidence that a crime has been committed, then they should normally be, the suspect, the accused, should normally be charged with the offence.
That's irrespective of the age of the accused.
As a matter of principle, that, as I understand, is correct. Officers do exercise ultimately a discretion, which in relation to adult accused may be exercised in relation to very minor matters. I'm told that in relation to children, discretion may, for example, be exercised in cases arising under Section 37, depending on the particular circumstances.
So is the general, as it were, public interest decision about prosecution one which is regarded as more appropriate for the fiscal
Indeed.
Than to the police?
Indeed.
Yeah.
And the Court has before it, in the intervener's appendix, the guidelines issued by my predecessor in relation to the reporting of cases involving children to the fiscal, the joint reporting to the fiscal and the reporter, and also the guidelines that are applied by the fiscal in such cases, which set out the presumption against prosecution unless there is a public interest in favour of that.
By then the charging, of course, has already happened.
The charging by the police has already happened, and it's perhaps a feature of the Scottish system that the charging decision is one made by the police in the exercise of their general responsibilities. I may say that this case has highlighted the absence of any guidelines specifically on the question of the charging of children, and I've instructed that the question of whether there should be such guidelines should be put under active consideration, having regard to the particular policy considerations that arise in relation to children. Whether or not, what the result of that will be, I plainly can't say, and it will require consideration with all relevant interests. But the second matter that arises in terms of practical issues is the question of, under the current law, the disclosure of the charge in the context of proceedings such as those faced by the appellant. In this case, a dispute arose as to whether there had been a charge at all, and that dispute was resolved by way of an pre-trial evidential hearing. And so in this case, there is no question but that the information about the 2009 charge was disclosed and a matter of public in the context of, albeit in the context of court proceedings that are not yet public, was discussed.
And would the, I don't know how it works in Scotland, Lord Advocate, would that, the evidence and the decision of the sheriff be reported in the meantime, or
no.
reporting restrained pending trial?
In Scotland, judgments that are produced in pre-trial are routinely not made public until after trial.
Yep, thank you very much.
Now, My Lord Reid raised the question of whether or not what the disclosure would be in these cases. Of course, there may be cases where the matter is not in dispute. It's a matter of agreement. The judge is simply told that the defence is not available. I suppose that in itself involves an implicit disclosure for the purposes of the Act. If it's not a matter of agreement, then the question would be dealt with either in a pre-trial hearing or should it arise in the course of a trial, potentially, I suppose, in a trial within a trial. But
I'm rather intrigued as to how an issue could arise as to whether there'd been a previous charge. Is there not some central collection of charges down the years?
I think there are a number of databases on which criminal record information is retained.
A number of them.
The police have a number of different databases. As I understand it, this matter wasn't on the ordinary criminal history database.
Oh.
And indeed, in this case, the charge was identified by the Procurator Fiscal from an electronic database available within the Fiscal Service. And I should say, by way of a wrinkle, that applying the Crown Office's rules on the weeding of written records, any written record of that will have been disposed of. The electronic records have not, while the aim is that they should apply the same rules, pending the child abuse inquiry, all electronic records have been retained, and it was from that electronic record that this particular charge was identified. Now, I understand it's also available on a particular database held by the police in relation to, as it were, crime records, but hadn't been passed by the police to the Fiscal in this case.
So, am I to understand your concession about the engagement of Article 8, that it extends to both the disclosure that would take place in a pre-trial evidential hearing, but also if there was agreement and the judge was simply told that it's accepted that there was this prior charge?
I'm content to accept that, my Lord.
Yes. Thank you.
And that perhaps takes me to the third of my preliminary issues, which is the question of the correct legal focus for this case. In my submission, the essential complaint here of the appellant is that as someone who has been charged with a relevant sexual offence, he is treated differently by the law from someone who has not. In other words, it's a discrimination point, or it may be put in a different way, that a failure to differentiate between charges against children and charges against adults is unlawful. Again, in my submission, it's a discrimination point. It's essentially Article 14 with Article 8. In my submission, Article 6 is not applicable for the reasons which are set out in my case, and I don't intend to elaborate on those. And so far as Article 8 is concerned, in my submission, the criminalisation of sexual conduct between an adult and a child does not engage Article 8, and I rely for that proposition on the observations in the Queen and G, which the court has at tab 1, volume 1, tab 6, at paragraphs 9 and 10 per Lord Hoffman, and at paragraph 54 per Lady Hale, and also on the High Court case of Logan and Thompson, which the court has in volume 3 at tab 32.
I just wonder, is it doesn't engage or doesn't constitute an interference? I mean, for example, there was a criminalisation of homosexual behaviour between an adult and a child, but not of heterosexual behaviour. Say if a child was over the age of 15, then would Article 8 not then be engaged for the purpose of being able to rely on Article 14?
Well, I think the way that it's put, if I remember, either by Lord Hoffman or perhaps by Lady Hale, it doesn't involve any want of respect for the adult to prohibit the adult, for the adult's private life, to prohibit the adult from having sex with a child.
That sounds like saying it's not an interference.
That's Lady Hare.
And I take her to be saying it's not interference.
Yeah.
And likewise Lord Hoffman at paragraphs 9 and 10. And the observations in G in the United Kingdom in tab 9, MS 296 at paragraph 35, where the Strasbourg court did accept that Article 8 was engaged, has to be looked at in the particular circumstances of an accused, himself a child, in apparently consensual behaviour. Now, I should say immediately that I recognise that the statutory defence at issue here is one that also applies to the Section 37 case, and therefore it may be that in that case G and UK would be engaged.
But what Lord Hoffman was discussing was a circumstance where the defendant accepted that sexual intercourse with a child under a certain age was quite correctly prohibited, but was seeking nonetheless to argue a separate Article 8 point.
Yes.
If he hadn't made the concession of the correctness of the prohibition, would the prohibition itself not be something that one would have to justify under Article 8? One could quite readily do so, I'm sure, but would it not have to be considered?
Well, I certainly take from those opinions that to prohibit sexual intercourse by an adult with a child simply doesn't engage Article 8.
Well, it doesn't engage or doesn't interfere. I mean, there is a very slight difference between the two, perhaps in many contexts, but in control of one's sexual activities surely brings one into the realm of Article 8, does it not?
As a general proposition, that's undoubtedly correct, my lord.
So the question is whether Article 8 is engaged, but that there is no interference because of the egregious nature of the activity that's being controlled. It may not matter for this case.
It may not, my lord, except that, well, I can see that it perhaps changes the focus, whether one's looking at differentiation in the way in which sexual conduct is controlled, and differential treatment in relation to the disclosure of information, which has may then be relied on and has significant consequences in the context of criminal proceedings. Yeah. I don't think I need to labour the point further. The point is there. The fourth preliminary point is just in relation to Mr. O'Neill's initial remarks on, as it were, constitutional approach. Perhaps I can just add 2 points. The first is that if legislation can be applied compatibly or incompatibly, then the obligation on those charged with its administration, and whether it be the court or, I suppose, the prosecutor in the context of the criminal law, may save the legislation from a finding of incompatibility. And the second point is, and I make these simply as general points, alive to perhaps the very general nature of some of the points that Mr. O'Neill was making, that there must be limits to the freedom of an appellant to rely on potential breaches of the convention rights of others when one's addressing a question of the compatibility of legislation. I don't put it any more strongly than that. And so with those preliminary remarks, my lords, I wonder if I might make some observations on the question of justification. And in my submission, the correct practical focus for the court is that the accused in a case of the sort that one's concerned with is being prosecuted as an adult, or at least as someone over the age of 16, in respect of an allegation that he has had sexual intercourse with a child. And the second point is to observe the basic principle of the legislation that sexual intercourse with a person under 16 is unlawful. And I allude there to the remarks of Lady Hale in the G case at paragraph 46, MS 223. And the third point, which I don't envisage to be at all controversial, is that the relevant sections of the 2009 Act serve an important legislative objective, namely the protection of children not only from predatory adults, but also from premature sexual activity. And that general legislative aim is articulated in the policy memorandum, which is in tab 3 at paragraph 114, MS 131. And the importance of the aim can be seen in the opinion of Lady Hale in R and G, particularly at paragraphs 45 and 49, where she dwells particularly on the aim of prohibiting, deterring, preventing premature sexual activity. These legislative objectives should, in my submission, be understood in the context of the state's obligation to protect children. And one can see the impact of that on, for the margin of appreciation, in my submission, the area of discretionary judgment, reflected in R&G, tab 6, MS 225, paragraph 54, per Lady Hale, and also in the Strasbourg case, G in the United Kingdom, tab 10, MS 296, paragraph 38, and also in MD and Ireland, tab 12, MS 376, paragraph 36. And in my submission, this is a legislative objective. The legislative objectives can justify creating an offence with no defence of reasonable belief as to age. It would be within the area of legitimate legislative judgment to create an offence with no such defence, as is the case for children under 13. In effect, such an offence has the object, as Lady Hale put it in G, of making the male take responsibility for the choices that he makes. That's at paragraph 46.
In other words, Lord Advocate, do you submit that if the choice had been made that this defence should not be available in relation to females between the ages of 13 and 16, that would be a legitimate?
That would be a matter of legitimate legislative choice. My Lord was in the chair in the case of Brown, and as I understand it, between 1923 and 2008 in Northern Ireland, there was no such defence. And as my Lord put it right at the end of his judgment at paragraph 39, this is Brown, volume 4, tab 38, at MS 1133, my Lord put it this way: if you have sexual intercourse with someone who is clearly a child or young person, you do so at your peril. And in a sense, that's the legislative objective that underpins a statute which has no defence of reasonable belief.
But the difficulty for the respondent arises when it's decided to make the defence available to some.
Indeed.
But that's why you say the focus has to be on Article 14.
It's really an Article 14 point. And of course, it's not irrelevant to, when thinking about the Article 14 point, to be alive to the range of choices that are available. And depending what my lords do with the case, it may not be irrelevant to understand that there may be a range of choices are available. Just perhaps to further and it's really perhaps the same point. I've taken the liberty of laying before the court a brief note which simply sets out the history of the legislation in Scotland, and the court can see there that initially there was a general defence of reasonable belief between 1885 and 1922, and then that was modified and then changed in various ways in 2009. And I draw the contrast with the approach that was taken in Northern Ireland, where between 1923 and 2008, the defence of reasonable belief was disapplied completely. And that perhaps illustrates the potential for different legislative judgments to be made in this area. Okay.
Can you help us, Lord Advocate, with looking at this history and relating it to what the Parliament was told? I've had trouble following this. I suspect the bill may have been, well, the bill seems to have been altered during its passage through Parliament. At MS 3026 in the appellant's case, we've got the policy memorandum quoted, and paragraph 131 tells us that the bill differs from the Scottish Law Commission proposal by restricting the defence to those not previously charged with a like offence, which was the phrase used in the 2005 Act and the earlier, the 1995 Act and the earlier legislation. And we're told this reflects the current law, which indeed it would if it were a like offence. And then 135, a bill retains the requirement that the accused not previously been charged with a like offence. Now, but when we go on to what the Parliament was told at 528, what they were told in oral evidence, but by there, the references to relevant offences, the bill at that stage, we can see defined that expression by reference to an order-making power, to be orders to be made by the Scottish ministers. Then the committee's report at 530, paragraph 309, goes back to the formula a like offence, and then 312, the committee support this in keeping with the 1995 Act. And then 531, the response to that by the Scottish Government, just over the page, second paragraph, refers us to section 5.5 of the 1995 Act, and then we're told it's replaced by the provisions of this bill, which also restrict the defence to those not previously charged with a like offence. This is not, therefore, a new approach. Now, obviously, the final Act defines relevant offences in a schedule to the Act and is much wider than the old concept of a like offence.
Yes.
So just like, what happened?
I regret, my lord, I can't
No, if you can't.
say immediately. I mean, I can certainly find out.
Yeah.
I mean, I speculate, and it's perhaps dangerous to do that. It may be that like offence was being used in a loose way, but I would need to check the terms of the original bill.
Yes.
It's not in the original bill.
So
It's not in the original bill, just change its relevant offence. Yeah.
it's the same. Mr. O'Neill's busy
Yeah.
looking at the
But
bill.
there obviously was an amendment at some stage to change the definition function being that of a minister's exercisable by statutory instrument to being that of a parliament itself in primary legislation.
Yes, I'm afraid I haven't tracked that, my lord, and I apologise for that. I might just make this point in relation to the, it's perhaps anticipating, but since the court has what was said to Parliament before it, it won't be lost on my lords that I found on what was said by Mr. McNichol of the Scottish Government Legal Directive, where he talked about the charge being a shot across the bows, something that effectively puts the individual on notice, and that's quoted by my learned friend in his case at MS 3028 at the top of the page.
Well,
And I'll
you
perhaps
have to
come
deal
on. I'll
with
perhaps come on to say something more about that. But it wouldn't be correct in my submission to say that this is a point that is not foreshadowed at all in the discussions. I entirely accept what was said by the policy official in the same passage referred to sexual predators and so on.
what does the
You can't
policy...
defend that.
Sorry,
You can't defend the reference,
I don't defend.
even in the Court of Justiciary, to sexual predators. It's too much of a jump.
I don't suggest that. I certainly don't suggest, my lord, that justifies or explains how the line was drawn. What I think I can say is that it was drawn in a way which minimises the potential for the defence to be relied upon by individuals who fall into that particular category.
Well, yes. You've got a least intrusive problem there, haven't you, Gordon?
Well, I may do,
Yes.
my lord, which is why I seek to, I focus on the point about notice and warning as the particular.
Very helpfully, in this note you've just handed to us, historical note, there's a reference on page 2 to your explaining that the exclusion of the defence was broadened in 2009, and I'm afraid this is a point that I haven't picked up. There was some broadening in terms of charge, and you refer there to Gordon criminal law. Do we have that elsewhere? So what's the point that's being made there?
The point that's being made is that under the equivalent English provisions, charge was interpreted to mean, in effect, if I understand it correctly, full committal, if that's the correct term.
Oh.
And so Gordon at least expressed the view that charge in the previous legislation meant, in effect, charge before the court, and indeed he took the view that it may only arise when one gets to trial.
Yeah.
Oh.
And the peculiar or the change from that, at least that view of the previous law, is that the Act is clear that it's charged by the police.
I see. Thank you.
So previously, it would have been on foot of a decision made by the Procurator Fiscal, would it? Yeah.
Indeed.
And
And
indeed,
Gordon's view is correct, and
Yeah,
I don't
yeah.
suggest that it
Indeed,
wasn't.
there would be a commitment to trial if Gordon
Yes.
was right. Mhm.
Yes, if you go back to the 1922 Act, the philosophy seems to have been that you could mount the defence of reasonable belief once.
Indeed.
Now, that defence wouldn't be needed in the context of a police charge that was not proceeded with.
Indeed.
Yes.
Now, my lords, moving on from the proposition that it would be within the legislative area of legitimate legislative judgment not to allow a defence of reasonable belief, it follows that the question of whether or not to allow such a defence, and if so, whether to allow it subject to limitations, is ultimately a question of legislative judgment. And the context for that legislative judgment is helpfully said by the Home Office paper Setting the Boundaries, which the court has in volume 2 at tab 24. And I, of course, immediately recognise that in England and Wales, this consultation paper ultimately led to a provision or a provision in which the defence was allowed with no qualifications. But it is helpful in my submission to look to the what's said in that report at MS 755.
I'm not quite sure why. Did this play any part in the thinking of the Scottish Parliament?
It doesn't, my lord. I refer to it because it helpfully points out at 3.6.11 that there was in England and Wales a real divergence of opinion about whether the defence should be allowed at all or not. And there was a view that because the defence caused, as it was put in 3.6.11, such difficulties in the prosecution, that in fact there should be no defence of reasonable belief. And then at 3.6.12, the authors of the report reject that. They say the interests of justice and fairness require an honest mistake to be recognised. But the authors then go on to say, in the middle of 3.6.12, on the other hand, it is all too easy to claim an honest mistake when no such mistake existed. And there is evidence that some men specialise in the targeting of young girls, and they go on to propose limitations. And I refer to that simply to set, as it were, the practical context within which I say there is a scope for legislative judgment, both as to the allowing of the defence or not, but also whether or not, if to be allowed, the defence should be limited. And in my submission, the practical context is important here, because I accept that the 2009 Act imposes an evidential burden on the accused, to whom the defence of reasonable belief is available. The evidential basis for that defence to be advanced may arise from the Crown case. The accused may, in his judicial declaration or in a police statement, set the basis or articulate the basis for the defence, which the Crown then has to, in effect, overcome and satisfy the jury, notwithstanding that evidence that the crime has been established beyond reasonable doubt. And so the accused may never require to give evidence for the defence to be advanced. And it's, in my submission in that context, if one thinks about that practical context, one can understand, perhaps helps to put colour on the proposition that there is a legitimate judgment to be exercised about whether or not to allow the defence at all, and if so, whether or not it should be allowed without limitation.
It may not matter, Lord Advocate, to the questions which we have to decide, especially if you're right that it's largely a discrimination question. But it's section 39(1) which establishes the defence, is that right?
Yes.
Does the section say anything about onus of proof?
It doesn't.
And in the absence of it saying anything about onus of proof, what's the rule?
Well, it's certainly understood to simply impose an evidential burden, and I think that may be
Precisely.
That may be said in
It's for the Crown to demonstrate that he didn't, isn't it?
It's for the Crown to establish the crime beyond reasonable doubt, notwithstanding the evidence that it allows the accused to.
Once he's raised it, the Crown must disprove it.
Indeed.
Yeah.
There must be evidence upon which it can be raised. But that evidence could readily arise from the Crown case, indeed in the shape of a mixed statement at police interview.
Yeah.
So to that extent, the point that's made by the Home Office in setting the boundaries, that it's a defence which, depending on the circumstance, may be easily invoked and difficult to rebut, is, in my submission, a well-made one.
The Home Office is in the paragraph that you took us to, 3611, unless I've misread it, and I may have done in a hurry, seems to be aligning honest mistake with reasonable mistake at times. And in the context of 2000, that's not altogether surprising, because the House of Lords had decided in Morgan, in the context of rape, that an honest defence was enough, whether it was however unreasonable,
Right.
hadn't it?
Yes.
Yeah.
Well,
It's only when you get in England, at least, to 2003. Actually, no. I'm sorry. It's earlier than that. But there was a reversal of Morgan. There had to be an explicit parliamentary reversal of Morgan to establish reasonableness as part of the defence.
yes.
Yeah.
Well, and certainly the Scottish statute, it's reasonably believed. So,
Yes. Well, it always was with the young man's defence, the USI, but to rape it wasn't.
indeed. Now, my Lord, I make these points because it obviously doesn't go to the specific justification of the line drawn here, but it's important in my submission by way of background to the justifiability of the drawing of a line. And in my submission, to characterise the young man's defence as a political compromise perhaps elides the extent to which what the legislature has to do is balance its obligation to protect children and decide how far that aim, which might be advanced very effectively by an offence such as was available, an offence such as that in Northern Ireland up until 2008, where there's no defence. But the legislature may require to balance that against the rights and interests of the accused. And where the legislature chooses to strike that balance as a matter, assuming it meets the requirements of justification, is a matter for the legislature. And I do say that if one keeps in mind that the basic aim of this this group of sections, in this case, Section 28, albeit qualified by Section 39, is to protect children, that a line which limits the availability of the defence is rationally connected with the aim, the overarching aim of the legislation, which is to protect children.
Well, do you accept that the legislature, if it's going to introduce restrictions on the availability of the defence, has to articulate coherently what the aim is and what is sought to be achieved?
I certainly accept that it has, assuming that we're in the ambit of one of the Convention articles, so that Article 14 is engaged, as it is here, that I entirely accept that the legislature has to draw the distinction in a way that is ultimately justifiable.
Yes, but the first step in the proportionality exercise has to be an identification by those responsible for the measure of the basic aim that is sought to be achieved.
Yes.
It's not something that they can seek to justify on an ex post facto basis, is it?
Well, I suppose perhaps I'd take that in two
Yes, by all
stages.
means.
Two
Yeah.
stages, my lord. I think the first point is perhaps the level at which one pitches the aim, and I do say that one has to take this as a group of provisions directed to the protection of children, where Parliament's been prepared to allow the defence, but not to allow it without limitation.
Yes.
And that may have a bearing in due course as to what order may or may not be made here, and whether one can simply red pencil the the particular qualification, or whether one has to look at matters in a different way. So far as the particular line that's been drawn here by reference to charge, I point, as my lords know, to the idea that the charge is an official warning about sexual activity with a child under 16.
Now that idea was put forward in evidence to the Parliament Justice Committee by Mr McNichol from the Legal Directorate. But the policy department responsible for this would have been the Justice Department, and their policy memorandum, and supported by the evidence of Mr McLaughlin, put forward a different rationale.
Well,
to prevent serial predators from taking unmeritorious advantage of the defence.
Indeed, and of course, and entirely accept that this is my
Conception.
attempt to put these two things together, that by drawing the line where it's been drawn, it can certainly be said that the Parliament has sought to minimise the risk that individuals in the category that the policy official identified will be able to rely on the defence.
Well, does Parliament have to articulate its aim in the sense of, whether given various policy objectives, as my Lord has pointed out, do they have to decide which of those they are going to cleave to?
Well, in my submission, one has to be careful. I accept, of course, that one can look at all the material that's available to try and identify what the aim was here. But one has to be careful in my submission, perhaps particularly when one's dealing with legislative distinctions that are being drawn in the Article 14 context, that Parliament may simply not have clearly articulated the precise justification for every line that is drawn in legislation. And it must be open, in my submission it is open to if one's seeking to justify the line that's been drawn, it is open to me to seek to articulate a justification which is the best fit on the provisions which Parliament has chosen to.
I wonder if that's so. I mean, the whole point of a policy memorandum is to be a formal statement of the government's policy justification for the bill it's laying before the Parliament, and it accompanies the bill. Insofar as one can find here any distinct consideration by the Parliament, it seems to be, well, anything put in front of us is the stage one report by the committee, the gist of which is that it thought it was preserving the status quo.
Which it plainly wasn't,
Yeah.
for the reasons I've set out in my note. I entirely accept that note.
But you've helpfully abandoned the cliche of a shot across the bows. You've got that in the presentation to the subordinate committee. So that's in the bag for you. But what's it mean? You've explained what it means. A charge is an official warning about sexual activity with children. Now, if we were talking about a conviction of sexual activity with children, that would be utterly clear. But we're talking about a charge. So how can somebody charged, whether at the age of 8, 18, 28, regard the mere fact of a charge which didn't lead to a conviction as being anything which would permanently deprive him of a defence that he would otherwise have?
Well, I think perhaps the way to look at it is this, that if one takes my Lord Kerr's articulation of the policy of a piece of legislation which has no reasonable belief defence, and that being to, in effect, put the risk of having sex with a child or young person on the person who's having sex with a child or young person. They take the risk that they're wrong about the age of the child. And so the question then becomes, to which class of people should, in effect, have to take that risk? And I suppose I suppose that one might say that somebody who's had a warning in the shape of a charge about sexual activity with someone under 16 in the past, in effect, that's a class. What one could say, that's a class to whom of individuals who then are, then are in that category of taking that risk. I'm not putting that very well, my lord.
I think the underpinning of my lord's question is, how does a charge convey the warning? I mean, especially when it's arguably applied to an arbitrary group of people. For instance, someone such as this appellant who was charged when he was 14 years old,
Yes.
and it's not accompanied by any documentation which sets out in explicit terms what the charge is. No attempt is being made to convey the import to his parents. No attempt is made to ensure that he has legal advice as to the quite subtle implications of all of this. I mean, that I think is my lord's point.
I entirely take the point, and I'm not suggesting that everyone who is charged with a sexual offence with someone under the age of 16 will subjectively understand the implications of that. I certainly don't suggest that in terms of the defence that we're concerned with here. But of course, I come back to the basic point that we're concerned here with an allegation of sexual activity by an adult with a child. And the question is, which groups of adults should, is there a group of adults who in effect, must just take the risk that they may be wrong about the age of individuals with whom they have sexual activity. And the idea that someone who's had who's been charged of such an offence in the past falls into that category may be thought to have a rational connection with that question. If my lords aren't persuaded of that, then the answer will follow.
Is there any answer to the objection made against you that a warning can only function as such in relation to future conduct, and future charges don't necessarily relate to future conduct? In other words, you could be charged by the police with a relevant offence, and then subsequently be prosecuted for an offence which was earlier in time, but be deprived of the defence by virtue of the statute, even though there was no possibility of the warnings having served as any warning at all.
I suppose the question would come to be whether one could read the legislation with, as it were, an implicit qualification, were it necessary to do so, that it must be a charge which...
The charge would have to be antecedent.
Yeah.
You'd have to read previously as meaning previous to the conduct now alleged, wouldn't you?
Yes. Now,
Previously in 39(2)A. But you'd have trouble with 39(2)A little Roman 2 doing that, which is what excludes it. Oh, I don't know, perhaps you could do the same. Sexual harm order.
I suspect that if one required to do it in order to make the scheme compatible, one could do it. If that were the only problem that I faced, I suspect that the court would find a way of helping me on that.
Only a modest level of legislative gymnastics required.
Indeed.
Interpretive.
Now, The point's a short one. If the official, I say that the line's been drawn, line can be seen as justified by reference to the official warning, that's rationally connected ultimately to the aim of child protection here, that it can be justified if one thinks about the purpose of the of deprivation of the defence in the way that the Lord Kerr articulated at the end of Brown. If that and that, in a sense, would be a precautionary approach in relation to the sexual predator.
In a way, your task might be easier, Lord Advocate, if it was a blanket prohibition.
Well, indeed,
Yeah.
indeed. And it won't be lost on my lords that, depending on what my lords choose to do here, there may be choices that then have to be made, and my lords will understand that I'm concerned to make sure that those choices are
Yes.
not artificially constrained by the way that my lords approach this particular case.
Right.
Do you, and for the sake of completeness, do you have an answer to the point that made against you that relevant offences in Schedule 1 are not confined to offences of which an element is the age of the complainer?
The age of the accused or the age,
No, age of a complainer.
the age of the complainant?
But effectively, for example, if you are charged with indecent exposure, for example, how does that put you on warning about the need to check the age of a girl before you have sexual relations with her?
Yes. I think, I'll be corrected if I'm wrong, but I think all the offences in Part 1 of the schedule the articulation specifically qualified by reference
Yes.
to a person under the age of 16.
Oh, I appreciate that.
Sorry?
Yes, I appreciate that.
Yes.
But they're not offences which are inherently offences that which must be can only be committed against under. They're not underage offences.
Some of them are not. My lord is absolutely correct there. I think the only point I can make on that is that it's only a relevant offence, a charge for relevant offence if it's in relation to a complainer who's under 16.
Under 18, in fact, if you look at Schedule 1, page 75.
Sorry.
That wouldn't even be an element of the charge, would it? I mean, if you, for example, were a peeping Tom, and it so happened that one of the people on whom you had been peeping was a girl under 16.
The age of the complainer might be narrated in the charge, but it wouldn't be of the essence of it. My lord's absolutely correct.
Would it be, yes, Section 67 of voyeurism, would it be an aggravation that the person being looked at was 16 rather than 19? It strikes me that it does raise a question, particularly that sort of charge. I mean, how would that sort of charge, which on the laws enacted would merely be the police charging you, nothing further might be articulated thereafter, how would that give you a real warning about engaging in sexual activity with a young person?
Beyond the
happenstance, the person being viewed was under 16.
I suppose the starting point, my lord, is that adults ought to know that they shouldn't have sex with children. And the question here is not is I put it this way, perhaps quite a well.
But the defence hasn't really got to do with that.
Indeed.
It's it's not saying you're deprived of a defence because you should have known that you shouldn't have sex with girls under 16. It's removing any possibility of it's removing the mens rea
Indeed.
from the offence.
Indeed. Or it's removing the mens rea in relation to age.
Yeah.
The court in G is very careful about that. And I should say I recognise, Mr Neal has articulated hard cases by reference to charges where the accused was demonstrably innocent. perhaps the really hard case is the one that my learned friend Miss Ross articulated, where the availability of the defence is overwhelming on the facts, and one can certainly figure these as hard cases, which is which is why I've said something in my case, and I don't intend to elaborate on it about the bright line rule question. So, my Lords, ultimately, my Lords either accept the sharp justification I've advanced, or my Lords don't. If my Lords accept that, then my Lords could take the view that, having regard to the strong public interest in the protection of children, both against predatory adults and against premature sexual activity, that it can't be said that the balance that the legislation has struck is unfair. But if my Lords are against me on terms of the justification, then the question will fall.
Do you want to say anything about the least intrusive means, Lord Advocate?
Well, I think what can be said about that, my Lord, is that the various alternatives that have been proffered would all strike the balance in a different way. If the ultimate aim here is the protection of children, recognising that this is the reasonable belief defence is one that can be potentially easily invoked and hard to rebut, and recognising that the practical context that I sought to outline earlier, the various alternatives have been articulated would strike the balance between the protection of children and the rights of the accused in a different place. And in my submission, if that's correct, then none of these are truly less intrusive means of achieving the particular balance that the legislature here has sought to strike.
It depends whether you come within the category. In other words, if I've understood your argument correctly, if you adopt one of the alternative means suggested, it may impinge upon someone who isn't necessarily caught by this provision at present.
Well, possibly, but even if all that's happening is that it's shifting the balance, so let's say the defence is excluded by reason of a conviction of a relevant sexual offence, well, that's immediately shifting the balance between protection and the rights of the accused in the direction of the rights of the accused. And so the balance that each of these alternatives strikes is our different balance.
Yes, I see.
Which is why perhaps ultimately the question, if I get past the rational justification point, is one of fair balance rather than less intrusive means.
Could you just look at the alternatives that have been floated? I've got them conveniently in Mr. O'Neill's skeleton at 6.46.
Yes.
3040, but I dare say they're elsewhere as well.
Yes.
One,
I've made the point.
You've dealt with that, and you say presumably as to that, it won't catch the chap who has run the defence successfully before.
Indeed.
Yeah, all right. Two? How would you go about it?
Well, indeed. I mean, there's a serious practical question. Without going back to previous case papers, I don't.
You'd have to keep some sort of record.
I don't think there would be a record of circumstances in which individuals have previously relied on the defence.
No, if you knew about it, it wouldn't be difficult to prove it because you could find the transcript.
Yes.
But if you didn't know about it,
there's no central record.
Wouldn't be a record. Yes. Okay. Three.
Three is really the point that I made earlier, that this is a defence which could arise without the accused ever having to give evidence.
Right.
And when one has that in mind, one can immediately see how that shifts the balance, certainly shifts them in favour of the rights of the accused, the interests of the accused, but reduces the strength of the child protection aim.
I'm not sure what 4 really adds up to.
Four, I think, is based on examples from other jurisdictions where, in effect, the legal burden is placed on the, if I understand it correctly, placed on the accused to...
Oh, I see. Legal rather than evidential burden, yeah.
Yes, my Lord will see that at MS 3043 and 3044, that an accused must have taken reasonable steps to find out whether the young person concerned was over the age of 16. That's the New Zealand example. Now, well, in fact, there may well be people who can rely on the defence presently, but who wouldn't be able to justify rely on it if that was the balance struck. So it would be striking the balance in a different way, which would favour some and not favour others.
And you say that I take it that you could quite legitimately, in ECHR terms, strike the balance of having no such defence at all.
Indeed.
Yes. So you're inviting us not to be too intrusive in looking at the less intrusive means in that context.
Yeah, indeed.
So you're saying it's so far as that test is concerned, yours is a reasonable response.
Indeed, indeed. If I'm right in that prior proposition, then provided the differentiation that is drawn is one which can be rationally justified, then ultimately where to strike the balance is a matter for the legislature.
Have you said all you want to say on what Mr. O'Neill called, I think, issue 2, namely charges to people when they're children being significantly different from charges to people when they're adults and yet treated the same way in your legislation?
My Lord, I was going to come immediately to the less intrusive option, which is not figured in Mr. O'Neill's case, but I think initially mentioned in mine and picked up by the intervener, which is precisely the question of restricting or removing the exclusion of the defence in the case when the charge was against a child, and to look at the question of children. Because I accept immediately that in the context of the criminal justice system, children are treated differently from adults. And the policy reasons for that are reflected in the guidelines and the guidelines on joint reporting, which the intervener has produced. And I also accept that there are international standards which are relevant and which may inform the approach to convention rights here. And my Lord Reid, in the T case, analysed a number of standards relevant to the present issue. That's T at volume 5, tab 49, at MS 1632 to 1633. And he refers in particular to the Beijing rules. This is at top of page MS 1633, Beijing rules, which inter alia tell us that records of juvenile offenders shall not be used in adult proceedings in subsequent cases involving the same offender. I should say that that's a rule which is not applied, certainly to convictions of children in Scotland. As I understand it, convictions will appear on the schedule of previous convictions, whether of a child or not. And my Lord Reid also refers at 1632 paragraph 130 to a document from the...
enormous change in
Sorry?
English. It would be the most enormous change in English practice to eliminate from the antecedents, as they're called here, the criminal history of a defendant after conviction, any offence that had been committed before he was 17 or 18.
Well, indeed.
If only because easily the most criminous group
Yes.
in the country is between the ages of about 15 and about 24.
Indeed.
Yeah. The point's made in at the end of 131 that these rules are not binding.
Absolutely. And at 130, my lord referred to a recommendation.
Even in international law.
Yes, indeed. A recommendation of the Committee of Ministers, which is about entries in police records relating to minors shouldn't be used after the persons concerned come of age, except on compelling grounds provided for in national law. And in a sense, the point that my Lord Hughes has made perhaps is an example of the compelling grounds in national law, where a conviction history of a child may be relied on post-conviction as an adult.
So was any thought given before this enactment was brought in to the difference between charging children and charging adults?
There's no direct evidence that I can point to. What I can say is this, that Parliament has expressly excluded from the definition of relevant sexual offence charges under section 37, which is the older child, consensual intercourse between older children. And the court can see that at MS 52 in paragraph 1. Any of the following offences under this Act: A, an offence under Part 1 against a person under the age of 16, an offence under Part 4, but not an offence of engaging while an older child in sexual conduct with or towards another older child, section 37, or engaging while an older child in consensual sexual conduct with another older child. So my Lord can see that a line has been drawn to take out charges of consensual sex between older children. And so what's been left in, so far as charges against children are concerned, are the non-consensual offences in Part 1 and the offences in relation to younger children, children under 13.
That's very odd, though, isn't it? Because if the purpose of the exercise is to treat the previous experience as some sort of alerter
Yes.
to the law about age, a Section 37 experience in the past might well do so, but a non-consensual act probably wouldn't.
Well, but sorry, when I say non-consensual, I mean an offence where the complainer is non-consenting.
Yes, exactly.
Part 1. So that would be a charge against a child. We're hypothesising a charge against a child of an act of non-consensual, of a non-consensual nature.
So, I mean, for example, would the sharing of pornography between children be taken out of the category of relevant offences?
I need to check that, my lord. I mean, it's a specific exception for 37.
No, what's striking is what's been made a specific exception is really the most extreme form of sexual activity.
I entirely recognise that, my lord, and I think all I can say is, my Lord Wilson asked whether any thought had been given to the position of children, and I think it's plain that some thought has been given, but it may be a fair comment to say that
the appropriate thought.
The issue has not been thought through to the possibility of other types of charges against children.
But yes, I mean, it does that does strike rather seriously at fair balance. as far as a child's concerned, that the Parliament has seen fit to exclude from relevant offences the most serious sexual offence that an older child could commit against another child.
Well,
But-
I don't accept it's the most serious sexual offence that an older child could commit against.
Well, one of the most serious. It's a pretty serious.
Because the most serious ones are
Would be a
Part 1
non-consensual.
of
Yes.
the non-consensual
Yes,
ones,
but-
or the ones involving younger children, which are all left in.
Ah, yes. No, it's between. It's just in the 13th.
It's the 13 to 16, and it's specifically the offence in 37, which is specific.
I've read what it is. Yes.
Yeah.
But I think my Lord's point is that it's perfectly possible to conceive of less serious offences than that dealt with here, where no exception has been made for children, no separate treatment has been made for them. And that, as my Lord points out, is difficult to square with the proper balancing of the interests.
Yes. Let's check other offences. Children.
No, Parliament think it's the older offences because of trigger offences.
Yes.
Under that are all for those over 16.
Yes. I would need to look at this, because I'm reminded that the trigger offences in relation to older children, so sections 28 through to section 36, are offences which may only be committed by someone who is over 16. So in relation to the older child, I'll be corrected if I'm wrong, the only offence is section 37. And that offence is specifically excluded from the definition of relevant sexual offence.
Well, I think we'll all probably need to look at that a lot more closely.
No, if that's correct,
Yeah.
then
Yes, that's a different point.
then in fact one can it's perhaps a carefully calibrated exclusion, which leaves in the more serious offences that an older child might commit, namely against a younger child or non-consensual, but specifically excludes the section 37 case, which is always one which is can raise difficult questions.
Yes. Thank you.
Now, if that's correct, then one has, at least in the way that the legislation is framed relevant sexual offences under reference to the Scottish Act, what one sees a calibration of application to older children. And if I put it this way, we're certainly a world away from the circumstances in T, where the minor offence of dishonesty as a young person is held up against somebody as an adult. We're in an area where it's a very limited disclosure for a limited purpose, albeit important purpose. It may be said to be if my lords were to accept my general justification, it may be that, notwithstanding the policy differences between adults and children, that one can see that Parliament has sought to draw a line which is justifiable. And one may recall Lady Hale's analysis in G, to the effect that the interest in protecting children from premature sexual activity is no less important because the accused happens to be a child. It's the same public interest that's at stake, regardless of the age of the accused. Now, well, Lords, I should immediately say, in relation to the conversation that I've just had about the definition of relevant sexual offences in the 2009 Act, I should immediately acknowledge that the provisions which are brought in under the English and Welsh and Northern Irish legislation don't seem to carry that logic through, at least very clearly. Section 13 of the 2003 English 2003 Act is one of the relevant sexual offences, and Article 20 of the Northern Irish legislation. And these are both offences that can be committed by individuals under 18 with older children. Now, there's a difference in that it's under 18 rather than under 16, but I think I have to acknowledge that the logic hasn't been fully carried through. And indeed, some of the historic offences in Part 2 are not ones which, in a sense, are ones which could have been committed by children. But I can at least say that as far as the 2009 Act is concerned, the legislature appears to have tried to draw a line.
Yes.
My Lords, I think unless there's anything else I can do to assist the Lords, there are perhaps just two short points I'd like to make about the intervener's written submission. And it's really just by way of clarity. At paragraph 24, the intervener provides some statistics. And I am told that the Crown Office statistics on these matters are different. I can certainly have statistics provided if that's helpful, but I'm not sure that anything in particular turns on the numbers. And the second point is that at paragraphs 41 to 42, the intervener relies on an academic paper for the proposition that juvenile sexual offenders don't necessarily become adult sexual offenders. If it's framed as don't necessarily, I certainly take no issue with the proposition. But I would simply say that in the absence of an examination of all the relevant literature, one perhaps has to be a little careful about drawing strong conclusions in the absence of expert evidence.
I see.
So, my Lords, unless I can
Thank you very much.
assist the Court.
Yes, you could assist me in relation to what sort of remedy we should grant if we are with Mr. O'Neill.
Yes. The Court has before it the issue's been framed in terms of two issues, which are at the end of the statement of facts and issues. And I think I'm right in saying that it's open to the Court to reframe the issues if the Court considers it appropriate to do so. But the essential question that this Court requires to answer is whether or not the provision focused on is or is not incompatible with Convention rights. And the matter then falls to be remitted to the High Court to make any consequential orders. Now, it's plainly going to be helpful if this Court, as I'm sure it will, explains its reasons if that's the conclusion which it reaches. And for example, it may be important to acknowledge that while focus has been addressed rapier-like on section 39 2A1, that's one part of a package in which the legislature has decided to allow the defence but hasn't been prepared to allow it without qualification.
Yes.
And while the Court might say, for example, depending on the view that it takes, that the line that's been drawn in 32A1 is not compatible with Article 8 and Article 14 taken together, perhaps. I mean, that might be in a sense, it may be, I suppose that in itself might well leave open the question of whether one looks more broadly at the package of provisions.
The matter was certainly put more broadly by the High Court in its in granting leave, and I just wonder, is there a formal definition in the legislation somewhere of what constitutes the compatibility issue? I mean, I'm wondering whether it's defined by the parties' agreement in the SFI, or whether it is defined in some other way, for example, by an order made by the High Court.
I'm sure there's a definition either in the Criminal Procedure Act or the Scotland Act, and I know that Mr. Neal's been looking at the legislation, and it may be better if I let him
Thank you.
draw the court to the provisions. But my understanding is that essentially the court answers the question: is the provision compatible or not compatible? Then it's remitted to the High Court to make any consequential orders, including any order under the Scotland Act. Under 102.
Thank you very much, Lord Advocate.
Thank you.
Mr. Bryan?
My Lords, I have nothing to add.
Thank you very much. Mr. Neal?
I have a number of points which I'll keep to my 15 minutes, Lord, if that's
Good.
right. Picking up on Lord Reid's points, section 288ZA in the 1995 Act, as inserted by the 2012 Scotland Acts. Section 288ZA, subparagraph 2, defines compatibility issue as meaning a question arising in criminal proceedings as to be whether an act of the Scottish Parliament or any provision of an act is incompatible with any of the convention rights. So that's the general definition, and it doesn't change from that. But my Lord Reid probably asked me about another provision coming out of the Scotland Act, which isn't in the papers, and it's section 288, capital AA, and that is under reference to appeals to the Supreme Court on compatibility issues.
Yes.
And that, I think, this is the provision your Lordship had in mind.
Yes.
And it says this: for the purpose of determining any compatibility issue, an appeal lies to this court against the determination of criminal proceedings by two or more judges of the High Court. And then subsection 2, on an appeal under this section, A, the powers of the Supreme Court are exercisable only for the purpose of determining the compatibility issue. As you've seen, that's broadly defined in terms of compatibility of the legislation. And for that purpose, the court may make any change in the formulation of that issue that it thinks necessary in the interests of justice. That's 2B. And then 288AA subsection 3 then says, when it has determined the compatibility issue, the Supreme Court must remit the proceedings to the High Court. In this case, of course, the compatibility issues arose because of specific questions which were put by the sheriff, and it might be that any remedy could usefully look at the questions which the sheriff puts on there at page 3125 in the core bundle in the appendix part 1. So I'll just jump on discrete issues as they've arisen. So that's the statutory framework. On the issue of the procedure when the issue of the previous charging might arise, certainly the Renton and Brown, which is the Criminal Procedure Bible, says at paragraph 24-16 that the issue of cross-examining an accused as to his character might be allowed, but only in relation to where the reasonable defence is sought to be run, and it turns out there is a charge of a relevant offence. So the matter might, it says, competently be taken in cross-examination before a jury.
Well, that ties in with the Scottish Law Commission's proposal, which was not in favour of the provision that ultimately the Parliament favoured, but was simply a suggestion that when the defendant got into the witness box and said he had a reasonable belief that the girl was 16 or over, he could be asked about the fact, if it be the case, that he had been charged with a relevant offence, and it could be put to him that in those circumstances, didn't he have to take very much more care before he made a mistake like this? To which one of the answers given today, which I hadn't picked up before, is, oh, well, of course, he can run this defence without giving evidence at all, because the grounds for the defence may emerge in the prosecution case, and then the onus shifts onto the prosecution to disprove it. So the Lord Advocate is saying, there may be no scope for cross-examination of the sort that the Scottish Law Commission had envisaged.
Well, certainly all I'm saying is that in Renton and Brown, they certainly see it as possible that one might cross-examination, should it arise. But it's more likely, my Lord, that it would arise prior to it coming to trial, as happened in this case. And there was a pre-trial evidential hearing, but it's just the possibility is there that it might arise in the course of
There are two possibilities, aren't there? One is to permit the Crown to raise his past experience by way of cross-examination if he's giving evidence. Another is if he chooses not to do that, but elicits from the girl that she was in a nightclub dressed to the nines, along with a group of obviously older friends or whatever, and leaves it at that. At least one possibility, although it would perhaps involve a change in the rules of evidence, would be to allow the Crown then to adduce the evidence that he'd tried this on before.
Yes, that it is possible for the Crown to lead evidence of previous...
Well, that would depend on the Scottish rules of bad character evidence.
Which are not very developed. We rest still on the common law because the 2012 Law Commission report on prior conduct and more off has not been implemented.
So but it's there as a possibility
Yes.
if not properly.
Well, it could be legislated for, that's for sure.
Yes. It has to be said in this case, as I say, what happened is because there was a dispute over the relevant, whether there had been a charge of a relevant offence, because there was only the documentary evidence available, not the supporting tape recording and the like. There was an evidential hearing at which the Crown put police officers in the box in order to give sworn evidence to the effect that the documentation that they had, in fact, reflected that a charge had been made. So clearly there is scope for evidence, but as the court below has noted, the High Court notes at paragraph 26, page 3109, it does say that sort of pre-trial evidential hearing shouldn't be led before a jury, and the matter should be resolved out with the jury's presence if agreement cannot be reached. Again, this is something which is probably not actually necessary for my case, but it has come up, this issue about whether or not Article 8 in terms of sexual covers issues of sexual conduct. And my Lord Reid mentioned the case of a differential treatment of homosexual conduct as opposed to compared to heterosexual conduct. And that is specifically looked at and dealt with in the case of SL against Austria, which is volume 8, tab 74, page 2496, at paragraphs 41 to 42, which is MS page 2506, where the discussion is about making the unlawfulness of sexual conduct between 14 and 15-year-old boys with older men unlawful, whereas 14 and 15-year-old girls having sex with older men was not unlawful. So they actually found an interference that was not justified under Article 8 to there. So it's And in our, the Crown against G, where my learned friend referred to the judgments of Lord Hoffman and Baroness Hale, two of a divided 3-2 court did hold that Article 8 was engaged in the circumstance of the case, and the court and the European Court also held that it was. So it's...
Wasn't there a British case about the different ages of consent for homosexual and heterosexual behaviour?
The SL against Austria certainly dealt with that, but I think there were a number of cases primarily coming out of Austria all at one go. There's the British case was Sutherland against the UK, but that was a commission decision which ultimately, the commission decision was such that the British Parliament then changed the law to equal consent, but there was no formal, I think that was about 1998. Lord Reid asked about like offence. That is not a phrase that was used in the bill as introduced. And in the bill as introduced, under clause 29, subsection 5, it says, it referred to relevant offence, but it said a relevant offence means such offence or an offence of such description as may be specified in an order made by the Scottish ministers. So there was nothing on the face of the bill as originally introduced, which and the rationale was given for that as it means we're terribly flexible and can put anything in. It was not, however, the maintenance of the status quo. The reference to like offence was defined in the pre-existing law under Section 5 of the Criminal Law Consolidation Scotland Act 1995, and it lists just like offence for the purposes of the reasonable defence, just 5 offences, whereas we've seen the vast number of relevant offences. So clearly there wasn't a maintenance status quo. There was the idea that Scottish ministers could define anything. Ultimately, under pressure, the order power was translated into the Schedule 1 listing that we have. On that, my learned friend, the Lord Advocate has said that, well, these are all offences which are in relation done by adults against children. Ms. Ross, the intervener, has helpfully pointed out that's not entirely the case. The example of showing a child pornography under a child of under 13, that's criminalised by Section 23 of the Act, but that is an offence which is a relevant sexual offence, but it falls within the relevant offences, but it could be committed by another child. And it doesn't have to be committed for purposes of sexual gratification. It can be for purposes of putting the child in a state of fear and alarm. So, again, the legislation as drafted does not do what my learned friend, the Lord Advocate, has suggested.
Several offences against young children can be committed by an older child.
Yes, absolutely. And all the Part 4 offences are captured as well.
All the Part 1 kit. Oh, sorry, Part 4, yes. Part 4.
Yes.
And the Part.
Well, the Lord Advocate talked about there being a bright line rule, and it's part of the province of legislatures that they have to draw a bright line rule. But that's not capturing the complaint in this case, which is not that there is a bright line rule and some deserving fall on one side of it and some undeserving fall on the other. The problem with this case is that the rationale given for the rule is that it's to give a warning. But when one looks at it, as the Lord Advocate said, the warning doesn't have to have been subjectively understood, he said. And also, it doesn't have to be objectively justified. He says that in terms in his case at paragraph 10 and paragraph 26, page 3074 and 3082. So a wholly unjustified charge, which is not understood subjectively by the a person being charged, is still to be somehow justified because it's some kind of warning. So that is not a bright line rule. That's just it's not a rule at all. It's an exercise in tyranny, frankly, if it doesn't have to be subjectively understood or objectively justified. In terms of the issue of the relevance of international obligations, my Lord, the reference, of course, to the Convention on the Rights of the Child is, as a matter of international law, it is not binding. And, of course, that is stated by my Lord Reid at paragraph 131 of T against the Chief Constable of Manchester. But further along in this same judgment, at paragraph 134, again at page 1633, it is noted in your Lordship's judgment, some of the instruments are of greater significance than others, but they are consistent in their emphasis on the importance attached to the rehabilitation of minors and juvenile offenders and to confidentiality of their criminal records as an aid to promoting their rehabilitation. And references made to, among other things, the Beijing rules that a person should in practice be required throughout his adult life to disclose the fact that he committed a minor offence as a juvenile if he wishes to pursue a range of careers is difficult to reconcile with, and mutatis mutandis, we see here. It may not be binding, but they're actually of importance. Also against the background that we know that the Children and Young Persons Scotland Act 2014 does a sort of quasi-incorporation of the UNCRC within Scots law, part of section 1. Don't go so far as to incorporate it because that would be in breach. Well, it might be beyond the powers, but it's certainly something which Scottish ministers are enjoined to take into account. On the business of identifying the legislative objective and ex post facto rationalisation, as I say, the cases, we don't have the cases on this in the bundle, but the recent case of Lumsden, paragraph 54, although in the context of EU law, again, in the judgment of Lord Reid and Lord Toulson, the reference is made to the court having a duty to identify the objective of the legislation at issue. And as I say, what the leading case on identifying the objective or aim of legislation is Wilson against First County Trust. And there is some further discussion in the context of devolution, devolved legislation in the Scottish context in Imperial Tobacco against the Lord Advocate. But in both those cases, it is not a case that allows for ex post facto rationalisation. You have to look at what the legislature thought it was doing, looked at objectively from the terms of the legislation when it passed the legislation at hand. On a final point, we're back to sex, and it's simply that in a sense, picking up the intervener's exposition in terms of the effect of this provision, the creation effectively of strict liability in terms of future sexual relations, if one understands it to be a warning subjectively, and has taken that on board as a child. That in itself is an interference with Article 8 in the future, and as caused by this legislation as a warning. So therefore, that's another grounds for seeking its proper justification, which hasn't been given in the terms set out by my learned friend. Those are all the points I have.
Thank you very much indeed. I'm very grateful to Council for their helpful submissions and to those who have been instrumental in preparing the written submissions. All very interesting. We'll think about it and we'll let you know in due course. We're adjourned.